anything that I say that's incorrect. What I can relate to the court is that last week, there was a body floating in a canal north of Wesley in unincorporated Stanislaus County. While the sheriff's department was recovering that body at almost the exact same time, an individual who's now been identified as the defendant entered a restaurant in the city of Patterson and began telling people there that he had just killed a person and placed his body in the canal. He gave some reasons about why that happened. The sheriff's office is currently investigating whether there was a financial motive in this case. The defendant left the restaurant, and the sheriff's department was then contacted by the defendant's brother, who expressed concern that the defendant may have done something with his roommate. We now know that the body recovered from the canal is the defendant's roommate. That's the victim in this case, Anthony Pistoia. I have warned the family that I was going to, at this point, talk about some of the facts of the case as it relates to the injuries to the victim, and they are harrowing. We know that the victim suffered blunt force injuries over his entire body, including significant bruising and broken bones to his ribs, his face, and his skull. There was an area on his skull where it appeared as if a weapon or implement was used to claw away the skin around his skull, exposing the actual skull from the surface. His nose was essentially cleaved in half. His hyoid bone is broken so that the medical examiner believes that the cause of death could have been either blunt force injury to the body or it could have been strangulation. It is unclear at this point what it was. It also, the hyoid bone could have been broken by a blow to the neck occurring in the course of this murder. The defendant was interviewed by the Stanislaus County Sheriff's Department. At the conclusion of that interview, the Detective Martin with the Sheriff's Office informed the defendant they had a warrant to take clippings of his fingernails for DNA analysis. The defendant, in response to that, said that he would refuse to give those clippings. Detective Martin replied and said that they had a warrant, so it was going to happen. She then left the room, and we have footage of the defendant at that point attempting to rip off his own fingernails. The totality of the circumstances in this case, including video footage showing that the only person leaving or entering the residence that day was the defendant driving the victim's vehicle, that vehicle having a significant amount of blood in the trunk, so much so that it was pooling and soaking through to the trunk's undercarriage. The defendant's statements to the individuals in the restaurant and the defendant's lengthy and violent criminal history, including 2 convictions in which he suffered 3 prior strikes, 1 for a robbery and 2 for attempted robbery, as well as the fact that he was on felony probation for conviction in October for felony domestic violence when this incident occurred, should convince this court that this defendant, if he's able to make bail, even as currently set at $4.2 million, if he's able to make bail at all, he would represent an imminent threat to public safety. And I'd ask the court to hold the defendant on a no bail status.
Ms. Jensen?
Submitted.
All right. Court finds by clear and convincing evidence based upon the facts that are evident and presumption great that the offense was committed in a particularly vicious and cruel manner, and combined with the defendant's previous criminal history, that he does, by clear and convincing evidence, pose a significant threat to the community. If he were to bail out, court will set bail at no bail.
Thank you, Your Honor.
Probation bail remain as set. Probation, okay. Based upon the allegations that a new law violation has been committed, the court finds probable cause to believe the defendant is in violation of probation. It's revoked. Bail will be set at $75,000.